The default judgment here, and it goes further into comes now the above entitled court of record to review the records, summarily determine the facts, and dispose of the matter as law and justice require. The habeas corpus has been called the great writ of liberty. Historically, that is a side issue. In the early days, habeas corpus was not connected with the idea of liberty. It was a useful device in the struggle for control between common law and equity courts. By the middle of the 15th century, the issue of habeas corpus, together with privilege, was a well-established way to remove a cause from an inferior court where the defendant could show some special connection with one of the central courts, which entitled him to have his case tried there. In the early 17th century, the Five Knights case involved the clash between the Stuart claims of prerogative and the common law, and was, in the words of one of the judges, the greatest cause that I ever knew in this court. Over the centuries, the writ became a viable bulwark between the powers of government and the rights of the people in both England and the United States. The contents of the summary: jurisdiction of this court, exhaustion of administrative procedure, comedy, petition, findings of facts, conclusion of law, and conclusion summary. So the summary we have: Oliver Wendell Holmes once wrote, "I long have said there is no such thing as a hard case. I am frightened weakly, but always when you walk up to the lion and lay hold, the hide comes off, and the same old donkey of a question of law is underneath. Duty falls upon this court of record to lay hold of the lion, uphide the underlying question of law, and dispose of the matter as law and justice require." On January 15, 2016, Sherry and my family, my husband, my little ones, a people of the United States, filed in the above entitled court of record a petition for writ of habeas corpus by a people in constructive custody. The petition invited this court inquiry into the following. And again, I will state, like I did in the other video, that this is not getting into the fraud of them pulling in persons and these fictitious corporations that they have created that they do not have control over. This is just talking about actual men and women and Americans, not U.S. citizens, and all of this, that they have pulled the wool over our eyes. So this is what it's focusing on, not getting into any of their legalese and fraud. So letter A, I'm continuing to read down the side looking at the numbers. Letter A, the cause of the restraint. B, the jurisdictional basis of the restraint. C, prosecutorial vindictiveness. D, reasonable apprehension of restraint of liberty. E, strict compliance with statutory requirements. F, diminishment of rights. And G, charges of common barratry, maintenance, and champerty, if I say that right. The petition presents issues of both fact and law. It did not appear from the application that the applicant was not entitled thereto. Therefore, this court ordered the respondents to show cause by the writ should not be, why the writ should not be granted. Explicit return instructions were included as part of the order to show cause to enable the respondents to fulfill the order. All respondents were duty served with the petition in order to show cause. The record shows that no respondent made any return, no respondent requested more time to answer, and no respondent provided any objection to the proceedings. Analysis. Jurisdiction of this court. Tribunal, Unified United States Common Law Grand Jury. It is the duty of any court to determine whether it has jurisdiction, even though that question is not raised. In order for the exercise of jurisdiction to constitute a binding decision, the court has jurisdiction. We fulfill that duty by examining the sovereign power creating the court. But first, what is a court? It is the person and suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. Further, a court is an agency of the sovereign, created by it directly or indirectly under its authority, consisting of one or more officers established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, and authorized to exercise its power and in the course of law at times and places previously determined by lawful authority. The source of the authority is acknowledged by the preamble of the Constitution for the United States of America. The people of the United States, acting in sovereign capacity, ordain and establish this Constitution for the United States of America. The Constitution contains nothing that would diminish the sovereign power of the people, and no state may presume to do so. Further, the United States of America and each member state is a republic, which means that the people may act either directly or through their representatives. Here, the sovereign people are acting directly. Beyond ordaining and establishing the Constitution, what are the powers of the people? The people retain all powers to self-determine and exercise rights. The essence of the people's sovereignty distills to this: this decree of the sovereign makes law. Some have argued that the people have relinquished sovereignty through various contractual devices in which rights were not expressly reserved. However, that cannot hold because rights are unalienable. The people retain all rights of sovereignty at all times. The exercise of sovereignty by the people is further declared or clarified when one considers that the constitutional government agency have no genuine sovereign power of their own. All just authority of the constitutional government agencies is solely that to which the people consent. In the petition, the petitioner identifies himself as a people of the United States. As such, he decrees the law for this court and ultimately for the court as a court of record. This then is the sovereign power by which this court is created. The Constitution for the United States of America mandates that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. This is a case in law, in other words, proceeding according to the common law in a court of record. This case arises under the Constitution and the laws of the United States. It follows that the judicial power of the people of the United States shall extend to this case. Therefore, it is the grand jury as arbiter that shall be enforcer of the law. We read, if any of our civil servants shall have transgressed against any of the people in any respect, and they shall ask to cause that error to be amended without delay, or shall have broken some one of the articles of peace or security, and their transgression shall have been shown to 4 jurors of the aforesaid 25, and if those 4 jurors are unable to settle the transgression, they shall come to the 25, showing to the grand jury the error, which shall be enforced by the law of the land. Magna Carta, June in 15 AD, 12/15/61. It says Justice Powell in United States versus Calandra. The institution of the grand jury is deeply rooted in Anglo-American history. In England, the grand jury served for centuries both as a body of accusers sworn to discover and present for trial persons suspects of criminal wrongdoing, and a protector of citizens against arbitrary and oppressive government actions. In this country, the founders thought the grand jury so essential to basic liberties that they provided in the Fifth Amendment that federal prosecution for a serious crimes can only be instituted by a presentment or indictment of a grand jury. All right, and that's Costello versus United States. Grand jury's historic functions survive to this day. Its responsibilities, determination whether there is a probable cause to believe a crime has been committed, and the protection of citizens against unfounded criminal prosecutions. Brandsburg versus Hayes. Again, this is very small, and I'm just trying to read it for people who are interested in the actual law, true courts of record. So I'm on line 110 in that area. It says superior courts are courts of law. De jure courts are any duly constituted tribunal jury administering the laws of the state or nation, proceeding according to the course of the common law. Let's see. And governed by its rules and principles, as contrasted with a court of equity. Court of law means court of common law. In other words, a court for the people, coram ipso rege, which is to say, before the king himself. The decision of a superior court may only be challenged in a court of appeal. The decisions of an inferior court are subject to collateral attack. In other words, in a superior court, one may sue an inferior court directly, rather than resort to appeal to an appellate court. The decision of a court of record may not be appealed. It is binding on all other courts. However, no statutory or constitutional court, whether it be an appellate or Supreme Court, can second-guess the judgment of a court of record. The judgment of a court of record, whose jurisdiction is final, is as conclusive on all the world as the judgment of this court would be. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding. All right, and that's Ex parte Watkins, and then cited in Schneckloth versus Bustamante, if I said that correctly. But all the case law is here and can be gone back into and studied, and it just lays it out for people. There's no there's transparency here. There's no hiding of the truth. You just have it right there out for everyone to see. The light shines on it. So no more hiding in the dark corners. So now I'm about 125 in that area. I don't even know if you can see it on your screen because it likes to blur when I create this video. It like really shrinks it down even more and blurs it, so I apologize, but that's why I'm reading it. It says here that the judicial tribunal, a court of record, is a judicial tribunal jury having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and proceeding according to the course of common law, its acts and proceedings being enrolled for a perpetual memory or memorial. Jones versus Jones. And then there's some more case law there. Ledwith versus Rosowski, and some others. And it says the people's remedy. The grand jury is not merely an investigatory body. It also serves as a protector of citizens against arbitrary and oppressive government actions, and must be both independent and informed. United States versus Calandra. Historically, this body has been regarded as a primary security to the innocent against hasty, malicious, and oppressive persecution. It serves the invaluable function in our society of standing between the accuser and the accused, whether the latter be an individual, minority group, or other, to determine whether a charge is founded upon reason or was dictated by an intimidating power or by malice and personal ill will. We have a lot of that going on today. Exhaustion administrative procedure. Ordinarily, exhaustion of state or federal administrative procedure is a requirement before a court of another jurisdiction will review the proceedings of another court. This is founded upon the principle of comity. The courts of the United States, both equity and law, and the courts of the various states, both equity and law, are independent of each other. Federal courts have no supervisory powers over state judicial proceedings, state court systems, or trial judges. Thus, federal courts have no general power to correct errors of law that may occur from time to time in the course of state proceedings. However, in federal courts and a state court are not foreign to each other. They form one system of jurisprudence, which constitutes the law of the land, and should be considered as courts of the same country, having jurisdiction partly different and partly concurrent. And as a matter of comedy, one of such courts will not ordinarily determine a controversy of which another of such courts has previously obtained jurisdiction. In cases of apparent conflict between state and federal jurisdiction, the federal courts are the exclusive judges over their jurisdiction in the matter. That being a given, federal intervention is only proper to correct errors of constitutional dimension, which occurs when a state court arbitrarily or discriminatorily applies state law. The rule of comity does not go to the extent of relieving federal courts from the duty of proceeding promptly to enforce rights asserted under the federal Constitution. And all considerations of comity must give way to the duty of a federal court to accord a people of the United States his rights to invoke the court's powers and process in the defense or enforcement of his rights. As to the principles of exhaustion of state remedies, the petitioner is not founding his petition on the principle embodied in 28 U.S.C. 2254. The basis of petitioner's petition is addressed in section versus petition below. However, we will address it here. In Friske versus Collins, the court's view was that exhaustion was not a rigid and inflexible rule, but could be deviated from in special circumstances. In addition to the class of special circumstances developed in early history of the exhaustion rule, exhaustion was not required where procedural obstacles make theoretically available processes unavailable, where the available state procedure does not offer swift vindication of the petitioner's rights, and where vindication of the federal rights require immediate action. Exhaustion today is a rule rooted in the relationship between the national and state judicial system. The rule is consistent with the writ's extraordinary character, but it must be balanced by another characteristic of the writ, to wit, its object of providing a swift and imperative remedy in all cases of illegal restraint upon personal liberty. That is, it is not a rule defining power, but one which relates to the appropriate exercise of power. The court noted that where resort to state remedies has failed to afford a full and fair adjudication of the federal contentions raised, either because the state affords no remedy or because, in the particular case, the remedy afforded by the state laws proves in practice unavailable or seriously inadequate, a federal court should entertain a petition for habeas corpus. Otherwise, a petitioner would be remediless. In such a case, the applicant should proceed in the federal district court before resorting to the Supreme Court by the petition for habeas corpus. 28 U.S.C. 2243 provides as follows: issuance of writ. Return, hearing, decision. A court, justice, or judge entertaining an application for a writ of habeas corpus shall forthwith award the writ or issue an order directing the respondent to show cause why the writ should not be granted unless it appears from the application that the applicant or person detained is not entitled thereto. The writ or order to show cause shall be directed to the person having custody of the person detained. It shall be returned within 3 days, unless for good cause additional time, not exceeding 20 days, is to be allowed. The state has been duly served, and the state has not made, and apparently cares not to make a return. This question of timeliness constitutes a special circumstance justifying deviation from the exhaustion rule. Exhaustion is not required where procedural obstacles make theoretically available processes unavailable, where the available state procedure does not offer swift vindication of the petitioner's rights, and where vindication of the federal rights requires immediate action. Until the case is resolved in the district court, the petitioner will be unable to present his claims to the state Supreme Court. This delay and lack of timeliness is further special circumstances. In the interim, the petitioner would be required to lose his liberty because of the lack of swift state vindication of his rights. Comedy. Comedy is one court giving full faith and credit to the judicial proceedings of another court, providing that such proceedings do not violate its own rules. Though comedy is not mandated, it is encouraged by the Constitution for the United States, Article 4, Section 1. However, comedy does not mean that one court involuntarily gives up its jurisdiction to another court. Comedy does not mean that one court must respect the improprieties of another court. Comedy does not mean that one court must submit to the whim of another court. Further, comedy cannot enter the equation when the question there before the courts concerns which of the two courts has jurisdiction regarding the vindication of the rights of the petitioner. The protection of the petitioner's rights from encroachment by the state is the innate responsibility of the federal courts. And if I butchered these words, that's just what happens. I am doing my best here. Let's see, in the United States, the habeas corpus exists in two forms, common law and statutory. The petitioner has chosen habeas corpus as common law in the court of record. The Constitution for the United States of America acknowledges the people's rights to the common law of England as it was in 1789. What is the common law? It does not consist of absolute, fixed, and inflexible rules, but broad and comprehensive principles based on justice, reason, and common sense. The common law is also the Magna Carta, as authorized by the Confirmatio Cartarum. If the accused so demands, the Confirmatio Cartarum says our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points, that is, to wit, the Great Charter as the common law, and the Charter of the Forest for the wealth of our realm. In other words, the king's men allow the Magna Carta to be pleaded as the common law if the accused so wishes it. Magna Carta says, henceforth the writ, which is called, Praecipe, shall not be served on anyone for any holding so as to cause a free man to lose his court. In this case, the free man's court is the court of record of the petitioner, as above entitled. The Constitution for the United States of America, Article 3, Section 2, Clause 1 says, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. The judicial power is thus extended to the habeas corpus case at law in the above entitled court of record. The above entitled court of record invoking the extension of the judicial power of the United States upon a case in law is proceeding according to the common law as sanctioned by the Constitution, and considering the matter that has arisen under the Constitution and laws of the United States, as stated above, the rule of comity does not go to the extent of relieving federal courts from the duty of proceeding promptly to enforce rights asserted under the federal Constitution. And all considerations of comity must give way to the duty of a federal court to accord a citizen of the United States his rights to invoke the court's powers and process in the defense or enforcement of his rights. This court accepts the duty, obligations to proceed promptly to enforce rights and asserted under the federal Constitution. Thus, this court has the subject matter jurisdiction to examine and act upon the petition for habeas corpus. Further, the parties were duly served personally with a copy of the petition and the writ of habeas corpus. Thus, the court has in personam jurisdiction. Petition. Title 28 of the United States Code acknowledges that it is not the responsibility of the petitioner to know by what claim or authority the state acts, but that the petitioner may inquire as to the cause of the restraint. Petitioner has requested an inquiry into the cause of the restraint, but none of the respondents have returned any statements of cause of the restraint. Therefore, this court may presume that there is neither legal nor lawful cause of restraint. Petitioner has isolated 5 points upon which he bases his petition. Not getting into the language, but this is for men and women to speak up. Okay, so A, the lack of cause of the restraint. B, the lack of jurisdictional basis of the restraint. C, prosecutorial vindictiveness. D, reasonable apprehension of restraints of liberty. E, strict compliance with statutory requirements. And F, diminishment of rights. Because the respondents have made no return, this court must rule solely upon the evidence before it. As provided by the petitioner, Seneca wrote, "He who decides a case with the other side unheard, though he decides justly, is himself unjust." Mindful of the wisdom of Seneca, we proceed. This court has taken judicial notice of the federal rules of civil procedure, Title 28, United States Code, insofar as it is not repugnant to the common law. And that's FRCP Rule 55 regarding default is applied here. The record shows that the petition was filed, a writ of habeas corpus to show cause issued. The petition and writ were duly served upon the respondents. No return was filed. A notice of default was filed. So no claim may be made that the state court was unaware of this court's proceedings, nor may the respondents claim they were unaware of the consequences for failure to make a return to the writ of habeas corpus. Simply stated, the parties against whom a judgment for affirmative relief is sought have failed to plead or otherwise defend as provided by these rules, and that fact has been brought before the court by the affidavit in accordance with the FRCP Rule 55A. Findings of facts. Therefore, based upon the record before this court, the court finds that I want all people involved with my family to listen up, because this is not just to Judge Lindsay Partridge and Judge Hart and County Sheriff Jason Meyers and bar attorney Phil Wiseman and Ellen Rosenblum. all of these actors. It is to everyone since this point and before this point that have come in and have violated my family's rights. This is public notice to you. There are findings of facts, and this is from the Unified United States Common Law Grand Jury, the superior law of the land. And these orders, they reign true. And you have been ordered. Sherry and James, my husband, are people, as contemplated in the preamble of the Constitution for the United States of America. 2, this above entitled court is a court of record. 3, all respondents were duly served and the court personnel were apprised of the petitioner's claims and the writ. All respondents had full notice and fair opportunity to argue their cause, and respondents did not argue their cause. 4, the respondents have not presented any legal or lawful cause of the restraint of Sherry and my family. The respondents have not presented any jurisdictional basis for the restraint of Sherry and my family. The court of the respondents did not fulfill the duty to determine whether it has jurisdiction in order for the exercise of jurisdiction to constitute a binding decision. 6, the respondents have not presented any evidence to prove the absence of prosecutorial vindictiveness by the respondents against Sherry and my family. Sherry, my family, my husband, my little ones have a reasonable apprehension of future restraint of liberty arising from the same facts. And this did happen. They ignored this order and have continued to oppress us and to commit crimes against humanity, crimes against my family. It's not okay. And I'm going to just keep reading and sharing because we have to speak out. We have the power within. Other people will try to oppress us, but we can rise above this, and they're not going to come out and try to protect and serve us and to come against themselves and their own. No, it's us who are to come out and to shine this light, and it's doing so in order to protect and to lift ourselves up so that we are not being oppressed anymore by a system and by people who have lost their way. So let's see here. It says 7, Sherry and my family have a reasonable apprehension of future restraint. 8, strict compliance with statutory requirements was not met by the respondents. 9, Sherry and James and my little ones have suffered an unlawful and illegal diminishment of rights, and we continue to. Conclusion of law. Further, the court concludes that 1, this above entitled court has the sovereign authority to proceed as a court of record with jurisdiction to act in the instant case and subject matter. 2, because all respondents were duly served and court personnel were apprised of the petitioner's petition and writ, and because all respondents have full notice and fair opportunity to argue their cause and did not do so, and because none of the aforementioned persons made a return, objection, or motion, the above entitled court has acquired a personam jurisdiction of each of the respondents. 3, because the respondents have not presented any legal or lawful cause of or any jurisdictional basis for the restraint of Sherry and my family, the respondents do not have any legal or lawful cause against or jurisdiction over me, my family, my little ones, my husband. 4, because the respondents have not presented any evidence to prove the absence of prosecutorial vindictiveness by the respondents against Sherry and my husband James and our little ones, and because of the burden of proof is upon the respondents. When evidence of procedural prosecutorial vindictiveness has been presented as a matter of law, the respondents have committed prosecutorial vindictiveness against Sherry and James and my little ones. 5, district compliance with statutory requirements were not met by the respondents. Sherry, James, and my little ones were denied due process. There is a reasonable probability. James probability that they will be denied due process. There is a reasonable probability that Sherry and James and my little ones will be subjected to future restraint of liberty arising from the same facts. So, let's see. Because Sherry and James have suffered an unlawful and illegal diminishment of rights, Sherry and James and my little ones will very likely continue to be subjected to further unlawful and illegal diminishment of rights if not immediately released. 7. It has become clear to this grand jury investigative body that the court has taken advantage through undue influence of its victims by manipulating people's free will for money, and is thereby guilty of common, barity, maintenance, and chaperty. Since this problem has been found in many courts in America, we have concluded the courts guilty of racketeering. 8. Conclusion summary. The respondents name village, town, city, county, state, or federal governments, Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum, by their default, their failure to return the writ of habeas corpus, have failed to prove their jurisdiction. Therefore, they each and all of them shall abate at law all proceedings in and relating to Marion County Circuit Court for the State of Oregon, Juvenile Department de facto case number. All of those juvenile case numbers de facto. None of the respondents, Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum, is an infant or incompetent. None of the respondents, Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum, have appeared in the proceedings. Default judgment to be entered by this court in accordance with federal rules of civil procedure, Rule 55-2. Sherry and James and my little ones, if not already released, are to be released straightway, and property seized, returned immediately. No damages are awarded. Chief Judge Ann Aiken shall confirm release of petitioner and abatement and inform the United States Common Law Grand Jury of the same by fax. The court, January 22nd, 2016. Signed. And there you have it. So, this is what I've done. I'm sorry for the length of it. I wanted to provide this for people who are interested in what's being said. It is a lot to say. And to read, and I'm just so much to get out there. But I think it's important to put out for people to hear, to see, to speak into the universe, because this is the truth of what is going on in these de facto courts. And I'm going to continue to shine my light on areas where the darkness is hiding in the shadows, in the corners, and trying to oppress families and our little ones, our children, our elderly parents, and just parents in general. So we can rise up together using our hands to love and to care for one another, and doing this all in love as we say no more. We're taking our power back, and we will end human trafficking one family at a time. Thank you for watching. Namaste.